welcome to episode 20 of The Global Lawyer. Today, we step into one of the most dynamic and I would say perhaps one of the most unsettling frontiers of contemporary legal practice, intellectual property in the age of artificial intelligence. We are living through a moment in which creativity is being scaled, replicated, and transformed at an unprecedented speed, and where the line between original and copy, between author and algorithm, between reality and simulation is becoming increasingly difficult to trace. And in these interesting times, the law is being called upon to do more than simply protect rights. It must interpret, it must adapt, and in many ways, it must redefine what we even mean by authorship and ownership in a digital environment where, well, what we see is not always what it seems. And it is precisely for this conversation that I'm truly delighted to welcome our guest today. And also a dear friend of mine, someone I often brainstorm with, and who is a true gatherer of people, always bringing others together, whether around her table, into her firm, or into thoughtful conversation. Dr. Flavia Mansur Murad Schaal, a leading Brazilian lawyer in intellectual property, a scholar with a truly international perspective, and a practitioner who has long understood that intangible assets are not merely legal constructs, but central drivers of innovation, reputation, and economic value. Now, Flavia, it's such a pleasure to have you here. Welcome.
Thank you, dear Marina. The pleasure is mine. I'm very, very excited to be here with you. Thank you so much.
Great. You're welcome. So let's start at the beginning. So your academic path is remarkably international, right? So you have degrees
Yeah.
from Université de Lorraine and Université Paris-Cité, and a Ph.D. that already reflects a deep comparative approach. So what first drew you to intellectual property as a field? And at what point did you realize that you wanted to go beyond practice and really invest in academic research and postgraduate studies?
Thank you. Thank you very much for this question. It's a long question, and if you
I
allow
know.
me, I'd like to tell a little bit how I began my practice. So, right after the university, I went to Paris. So, I
Mhm.
wanted to study abroad, and Paris was the place I've chosen by the time. It was in 1996. So, I stayed there for a while. I studied French as a language, and then I started a master program. So, it was not IP law. So I started with international commercial law by the time, and I had just one single subject about IP. But it was mostly related to international treaties, European Union that was about to begin. We studied how the countries were going to work or live together with the European Union, and also how the products and people were going to be moving towards the region. It was not right away trademark protection or patents, so it was like more broadly and more public law, let's say. And Paris was very important to me because I had the chance to study with a French student. It was not an international program. It was in a public university there.
Oh, I didn't
So
know that.
yeah. So all the French students were studying with me. So I have to be very competitive because they came very strong. And universities in Europe are very competitive. So we have to be up to their level. And so it was a very, very hard job for a young lawyer, let's say. It was right in the beginning of my career. And right after that, I came back to Brazil. and started my first job as a lawyer at an IP firm. It was not planned. Actually, we didn't have internet by the time. It was in 97. So I found a job in a newspaper where I put like a round circle. And so I applied to this law firm opportunity, and it was Guzmão e Labrini, which is a
Mm.
very, very good and important firm for IP in Brazil. So I went through all the levels in my career. So I climbed the ladder, which was very long, from junior to senior coordinator and everything. And I learned a lot about IP protection, trademarks, patents, and transactions, litigation, and also technology transfer, software. And by that time, I had the chance also to live in the domain name disputes. Um, we didn't have social media, but we began talking about how the digital world was evolving and changing how IP lawyers were shaping the new era of IP. So it was a very good base. I was very lucky to be mentored by José Roberto Guzmão himself and also Jacques Labruni. So I had the privilege of being with them and being their assistant. So for me, it was a very nice beginning. So I didn't begin by myself. I had very, very smart mentors, which is very important for the beginning of anyone's career. I think young attorneys and also experienced attorneys that could live this world.
Yes,
And
certainly. Yes, it's a pattern that defines from a very early stage
in Brazil, we
when you
don't use
see.
that. Yeah, we are not.
Yes,
Yeah, I don't know why, but it's so important to have a mentor in life
yeah,
and to have someone to talk to. We don't know anything. No one knows anything. So, and most of the experience or knowledge you acquire is by living the experience. So, if you
yes.
have someone more experienced than you that could live this adventure, like supporting your dramas or your challenges as an attorney, as a mother, as
Hmm.
woman that wants to be like successful, you have to be someone beside, you have to have someone beside you.
Sure, that's true. Definitely true. So, and what's interesting that in this path of yours is that your academic life and your academic experience, it doesn't feel detached from practice at all. It almost seems to anticipate the way you structured your firm. So, moving from theory to execution, you are now the CEO of Mansur Murad Advogados, your law firm, with a very clear vision. So, treating intangible assets not just as legal rights, but as strategic business tools. So, how did you go about structuring that practice in its early days? And at the same time, how did you balance the demands of building a firm with such a strong academic trajectory? Were there any particularly challenging moments in trying to reconcile those two worlds?
Well, Marina, a lot of episodes of challenging moments. So
I
we
can
don't escape.
imagine.
Yes, we don't escape. We have 20 years of law firm, and
Wow.
many things happen, and many things are about to happen. So, first of all, the academia is something that brings me to the opportunities of discussions, to being beside people that could bring other ideas to the table. We're also able to discuss something that happened, like case law and new ideas with students, with other people with other specialties such as civil law, commercial law, tax law, and antitrust. Everything is connected with IP. IP law is very international and very broad. So this multi ideas that we gather are part of this experience that we deliver to the client. As being a lawyer and owner of the firm, I came to a moment that I felt that it was time to run a firm like a company. So it was also a very good turning point in my career. So by beginning to be the CEO of my own firm, um, I thought that just having the law background was not enough. I have to be deeper than that and go to the management side of running a law firm. So before the pandemic, 1.5 years before, I entered in an executive program called PhD and at Easy Business School. So I don't know if you know it, but you might know, which is one of the very good executive education in Europe. It's one of the
Yes,
best,
yes,
but
yes.
they have a very good building and program here in São Paulo. So I went through finance, I went through marketing, sales, human resources, crisis management. I went to like pre case laws, not case law, sorry, previous cases about
Previous
management.
case
Where
studies, yeah.
well, and the classroom was full of directors and managers that were eager to also discuss their pains. Everyone has a challenge in their life. And it was very nice because other very experienced professors that had very broad careers in companies such as Pirelli, Itaú, and many other places that we recall being like pillars of our economic life were there to give us the best lecture they could. So the students were like thirsty for knowledge. And so I could apply all those things that I learned in the law firm because the law firm is a company. It's not because we don't sell products that we are not. We don't need to have this company mentality. So I put aside the law mindset a little bit for a moment. When I am a CEO, I run a company. I'm not running forcefully a law firm. So I have to have like a CEO mindset with all the challenges they have. So
Yeah.
when I assist a client that needs our assistant in IP, I try to pose all those questions to the client and I try to learn what he's living because he's asking the question, because he's living something inside the company that it's beyond the law. It's not always a law case. It's something that it's related to this, to his corporate moment. So even though it's IP, even though it's invention, innovation, software, or a contract or a transaction, you have to think the way he's thinking. And I have to understand what are his risks. So this is my way of doing business. So it's not thinking just an IP lawyer or just a CEO as a generalist that is going to solve his problem. That's the way I think,
Wow.
generally speaking.
Yes. Oh, wow. And I would say a competitive edge,
Yeah.
definitely. So,
Well,
yeah, that's what you've got. So now, fast forward to today. So you're no longer just building the practice; you are steering it. And so, tell us about your day today, your current day today as senior partner. because as not only in the law at the law firm and also but also in your role at IASP, the São Paulo Lawyers Institute, where you had the Intangible Asset Studies Committee, you really operate at the intersection of law, business, and leadership. So what does your day-to-day look like today? And more importantly, what kinds of decisions do you consciously make to deliver the best outcomes for your clients? And just one more thing, I'm curious, how does your background in IP shape the way you manage your team and think strategically as a CEO?
Well, thinking, I'll begin with the second question and then I go to the institute. So, how I shape my team. First of all, the firm is very professional. So I have directors responsible for finance, for the commercial side, HR, marketing, and everything is structured as a company itself. So everyone has its role and purpose to deliver the best service for the client. But this is the background. And then we have the teams. So we have the trademark team, we have the international practice team, we have the patent and innovation, and we have the litigation, and we have the contracts. So everyone deal with intangible assets, which means we don't deal with family law, with M&A or tax law, but everything that it's related to manage and protect the best intangible for the client. We're very fortunate because nowadays a lot of things are intangible, so everything is digital. An IP lawyer, in my opinion, is essential for the C-levels to think strategically. So our firm is beside them to assist in the best way possible. Why the Institute, IASP, is important to all this? Because we have the smartest minds in São Paulo to think out of the box. So in my committee, and I believe in all the committees in IASP, but especially for the intangible assets, we try to bring people that could open our mindset to new things. So the last time we talked about the tokenization and the new law regarding the banking side. So we have to think about, so this is not IP. I know it's not IP, but token is something inserted in the IP life. So if we have to get the principles of banking, we have to use the same principles elsewhere. So this should be IP in one way or another. So those guys are very, very welcome to our committee to talk about that, so we can be better to the client and bring better ideas and provide like interesting talks and invite them to talk out of the box, like I said. So this is how I manage the knowledge and the management at the same time.
Very, very, very interesting. And of course, behind all those decisions that you have to make, there are the cases, right?
Yes, that are the cases.
Yeah, and I imagine that your perspective as a leader is also shaped by the cases that marked your career, because it's often the most challenging ones that refine our judgment the most. So let's get into that. You've been involved in landmark disputes, particularly in areas like trade dress, 3D trademarks, and complex IP structures. Is there one case or perhaps a couple that truly challenged you, either technically or even strategically? And did those experiences change the way you approach your role today, whether as a lawyer, as a strategist, or even as a leader?
Yeah, I think the landmark is the Vigor yogurt case. So it's the protection of a 3D, the three-dimensional trademark of Vigor Greek's yogurt container in Brazil. So it represents an important development an important development in how shape and packaging are recognized as a trademark and as a brand element. So we got the rejection of the trademark office first. So they judged that the packaging, that the container was too simple to be reminded as a brand, as a trademark. So we got the rejection of the trademark, and we had to go to the courts. We went to the federal courts to prove that this packaging was, that this container was not merely functional, or it's not merely carried as a simple packaging format. So it was really a unique visual identity capable of identifying the origin of the Greek yogurt. So what happened in that case is that one of the central challenges of that case was to demonstrate the acquired distinctiveness of the container. What does it mean? Acquired distinctiveness, it's something that comes from the US law. It's not provided by the Brazilian law. So, although distinctiveness is one pillar of the protection of the trademark according to the IP law of Brazil, we don't have those kinds of concepts developed. We had to bring to the court a comparative law so we could prove the distinctiveness. And how was this made? Was this required combining legal reasoning with the market evidence and consumer perception had to be conducted as a survey with the Brazilian public as a whole. Okay, so our position was that the shape was not essential to the product itself, but rather a strategic branding asset. It was exactly what you just asked me. It was like a character. The container was a character. So it was belonging to all the advertising of the brand. It was belonging to all the social media point of view. It was central to bring to the public that this container was really recognizable at first. So if the shape or the figure or anything is recognizable directly and without showing the label, without showing the noun or the name Vigor, it means that you have a brand, a 3D brand in this case. And we were very successful in this case. We got the granting of the decision. And so the trademark office had to reverse its administrative decision to register the mark for 10 years. It
Wow,
was a great battle.
that's a
It was very
landmark. That's
exciting.
very interesting.
And Marina, what was very exciting in the end, because last year the law changed. So the way of, yes, analyzing 3D trademarks changed. And we could prove that we could have the same rights as a Coca-Cola bottle, for example, the Toblerone shape, and the Kit Kat case, for example, the Four Fingers. So many other cases that most of them are from abroad, but we could bring like other cases such as the Copo Americano from Nadir Figueiredo and the Yakult little bottle. So many other cases came up. And so that's the Brazilian innovation related to brands. So I was very proud to bring this case as a Brazilian innovation to the courts. And not only foreign cases such as Louboutin that we talk a lot, but those are really Brazilian cases. So this is why I feel so proud of being responsible for this until
Oh,
the
you
end.
should, because it is quite a contribution. Congrats. It's amazing. And okay, so let's broaden to a more broader and unavoidable conversation. I have to say that I loved your recent reflection on speaking about AI and copyright at the INTA Leadership Meeting 2025, especially your point that this debate has now moved far beyond technical circles. So you mentioned both the Napster case and the more recent Folha de São Paulo versus OpenAI as framing the same fundamental tension. So let me close with this question. How do you see the future of intellectual property law in this AI-driven environment? And what advice would you give to lawyers, whether young professionals or experienced practitioners, who want to build a successful career in this field today?
Sure. And this conference is the largest conference in the world regarding IP and similar rights. And so I was invited to speak with many other attorneys and many other professionals from around the world. Beside me on my right side was a professor that was responsible for the Harvard IP course, yes, the LLM. So it was a huge responsibility to talk about IP in Brazil. So
Another challenge, another one.
what a challenge. So, but I think I did well. So at least my very dear colleagues said that I spoke very highly about Brazil. So that's what matters. We need to be proud of our country and whatever happens here in development of the law. But I presented two cases. It was the two cases that I wanted to bring as a difference from the other countries' law systems. So the first case was I explained why in Brazil that case that was the Bart's case versus Anthropic. They were discussing whether this could be an IP infringement when the Anthropic trained their system with copyrighted works. So they were talking about a transformative right, and I was explaining why copyright in Brazil does not adopt the unfair use, the fair use model that it's related to transformative right in the US. So I said the concept of transformative use has no express legal basis in the copyright of Brazil. So our law does not welcome this kind of concept. And it was very important because there were many other attorneys from Europe. So Europe adopts the same system as ours, as continental law countries. Adaptation or transformation of a work is a derivative use according to Article 29 of our law. So it requires authorization from the author. And different from that, I presented a Brazilian case judged by the STJ, which is the Napster case. I believe you've heard about it. Yes. And although it's a very
it's
old,
not new.
dated, yes, it's a dated platform. They don't exist anymore, actually. But what was interesting to present is that the author, the plaintiff, they claim for moral right damage due to the unauthorized provision of 11 of the plaintiff's musical work. They were composition, so inserted in a platform without the indication of authorship. What happens in this case is that we have moral rights associated with this, and this leads to infringement and damages. This is a legal violation, so it would be different from the US law because they deal with another kind of protection of the authors. They don't have moral rights. So I wanted to bring the moral right, which is very, very continental law adopted system. So I had to explain that. And in the end, I wanted to say that also the platform, so Napster, had joint responsibility. So even though There was not like a damage, economic damage itself. It was a moral right, and the STJ recognized that the moral right was present because the failure to register also, as indicating the author's name, was an infringement. And
Very,
I have a second
yes, yes.
case,
Yeah, yeah. Okay. Oh, let's go. Let's see it.
if you allow me.
Go
In
ahead.
that
Yes, please,
presentation,
please.
yes, and I brought a very interesting case that everyone was talking about in the middle of the year, in the middle of last year. And it's a Folha de São Paulo case against OpenAI. I don't know
Ah,
if you've heard about it.
yes, yes.
Yeah, so Folha de São Paulo was very upset with
Mm-hmm.
ChatGPT, with OpenAI,
OpenAI.
because they were like collecting, reproducing, and using without authorization the articles of journalism to train their system, their AI system, and they're all copyrighted content. So if they're copyrighted, they're protected. And if they don't have authorization for that, it means that they're infringing Folha de São Paulo's right. And this went to the courts, and the basis was, the grounds of the case was copyright infringement of more than 100 journalism articles, reports, analysis,
Wow.
and graphics.
Wow.
Yes,
There
they
was something
use that.
similar yeah, I'm sorry to interrupt, in New York Times against um, AI, against open AI, isn't it? If
Exactly.
I'm not mistaken. Ah,
Yes, the same grounds, the same practice.
look at
Yes,
those.
exactly. And I think Folha de São Paulo was very fortunate
Mm,
because they showed also the unfair competition practice, which was stronger in Brazil than, as a market substitute, which means that people, consumers, or people that users with ChatGPT are substituting the Folha de São Paulo articles by prompting and asking what is going
wow.
on and what did Folha de São Paulo say, and etc. So this practice of trains and instruct is, and using AI tools, leads to what? Emptying Folha de São Paulo's rights. Nobody's going to pay for reading
For the
the
paper,
articles
for the
anymore
articles.
if you have it for free in an AI platform. And this case was nice because Folha de São Paulo showed to the judge that OpenAI made contact with them to an agreement,
Ah,
and they
haha.
couldn't reach an agreement.
Ah,
And so they
so,
used something that it's not very nice. They use hacking bots to
wow.
scrape the articles from the Folha de São Paulo's
No.
platform and circumvening the newspaper's paywall. So it happened more than 85,000 times
Times.
in a
Ah,
very short period, like in hours, in days.
oh my
So
God.
it was, but unfortunately, I just had access to the initial petition
Uh-huh.
because it runs in secrecy.
Oh,
So
I see.
OpenAI
Uh-huh.
requested that, and the judge
I can
granted.
imagine. Yeah.
Yeah,
So interesting. Wow, Flavia, these are amazing cases. And it seems that new types of rights or new elements are developing to be protected. IP law is a living right, right? And I think we are living. So your area of practice is booming. is
yes.
you are quite at the center of this revolutionary time that we are living. Very fortunate, I would say, because of your competence, of your skills, and of your trajectory.
Technology is booming. I think there's no way out. There's no turning back. We
mhm,
have to deal with those kind of new technologies
right.
and think how they could like survive in the legislation we have available. So now we're discussing what is the future of IP because all the bases and everything that we learned and based on is related to invention and to creation, to protection of the creation of a human being. And now we have machines coexisting
Mm-hmm.
with the creation, and we have to classify if it's really a creation or a product that comes out from the system. And we're discussing if a protected work that is being input in the system could
Uh-huh.
be used, and if the US law adopts fair use for that because they transform the right that outputs, and how come our legislation could cope with such a concept that we have never adopted? If it's not an infringement in the US, could it be an infringement in Brazil?
Yes, it's a great question. And you see, intellectual property law was at the end of the 19th century. It was when it was first studied and compiled and systematized in France. IP law was a very important element in it. It was quite internationalized. So I think again we are living in a time where IP is breaking new ground and bringing new. They are not fulfilling, but they are asking for deeper reflection on all of that and of everything that is coming um, in the wake of all this technology.
Yeah, I think everything is reshaping. And a couple of years ago, I wrote an article suggesting what the law nature could be of the outputs of the systems.
Mm,
And also, I discussed if we're facing a sui generis law, because we also protect the investors in the system.
yeah,
Someone has
yes.
put efforts to make this happen. And this investment is also a way of protecting someone that had the idea of putting this project in execution. So
Mm-hmm.
UK law is very keen of this idea. So for those who are interested in international law, I suggest following UK law on this because they talk very broadly about this when we were discussing software. And software was
Ah.
also one of the challenging discussion on what is the code and what is protected, what kind of law are we dealing. So we're just coming back with those kind of way of thinking. So it's very interesting.
Yeah, that's
We're not
oh,
finishing.
no,
We're
not
always
at all,
evolving.
not at all, not at all. Oh, Flavia. So now, as we come to an end of this episode, I just want to thank you, truly,
Thanks to
for
you.
no, because for such a such a thoughtful, sophisticated, and forward-looking conversation. Your ability to move so seamlessly between legal precision and strategic vision while never losing sight of the human dimension that you just mentioned behind creativity and innovation. This is all really genuinely inspiring. And
Thank you.
you remind us that even in a world increasingly shaped by algorithms where we are living, it is ultimately human judgment, responsibility, and imagination that give meaning to the law, right? So,
Totally.
And as this episode airs in March, so in the last day of March, it feels especially meaningful to highlight the presence of women in spaces that not so long ago were almost exclusively occupied by men. Conversations like this remind us that this is not a path already paved, but rather a landscape being charted, each step opening new ground for those who will follow. So not a finished structure, not at all, but a work in progress, carefully shaped over time through talent, persistence, and vision. And perhaps one day we will fully inhabit a world in which the differences between men and women are not barriers, but facets of a richer whole, like pieces of a living mosaic that together create balance and strength. So perhaps that is also the note on which we should close here our episode today. In times when technology challenges our most fundamental assumptions about authorship, truth, and creation, the role of law becomes more than protective, it becomes interpretative, almost philosophical. And in that point, I believe that there is someone that we should quote. It feels fitting to quote the words of U.S. Supreme Court Justice Ruth Bader Ginsburg, an exceptional lawyer, a judge, a justice of the Supreme Court, and a trailblazing advocate for women's rights, whose legacy continues to inspire many generations. So she says that truly a true commitment to listening to different voices, different perspectives, and different experiences is what allows the law to evolve with wisdom and integrity. So we leave you with that thought. And Flavia, again, thank you so much for being here. And thank you all for joining us on The Global Lawyer. Until next time. Bye-bye.
Bye bye. Thank you, Marina.